substantial question of here you also exhibit A and E. My lord, kindly come to.
Which is that substantial question?
Yes, that is. Yes, that is the. Relying on the judgment of the apex court, my lord. I have framed this. Here is also one agreement of 2009 which is marked exhibit without objection. And original landlord passes in March 2009. Agreement is of 7/8, and then it proceeds, my lord. 7 months after his death, a notice is issued and the suit is instituted for personal necessity. 5-6 lakhs were also paid under the agreement. Now, only ground that the appellate court, trial court has not discussed any of these issues. Appellate court says that since it is an unregistered agreement, so the judgment which was before Honorable Apex Court also, my lord, it was related to unregistered agreement.
What is the date of agreement?
Yes, my lord, that is it. I'm discussing it. Agreement is 30th of October 2008.
2008.
And Exhibit A is, my lord.
Just a moment. There is an amendment in the Registration Act
2002, yes. There is an amendment.
It is compulsorily registered.
For part performance.
For part performance.
50, I'm not in part performance.
Okay, you are not seeking.
I'm not. That is a different suit for my.
That's
specific. I am seeking that
for
since.
specific relief. For specific relief act is.
There is a different suit. I am saying that because of this agreement, the agreement itself is stipulated in clear terms that I have not to pay rent. That agreement is stipulated.
Okay.
So my landlord-tenant relationship comes to an end with this agreement. That is our case. Okay. And original landlord passes away sometime in 2009. After his death, 8 months, then a suit is instituted. Our basic case is that after this agreement, the landlord-tenant relationship has come to an end. That is the juror relationship that has come to an end. And the trial court says that since it is an unregistered agreement, so therefore it is inadmissible. My lord, will take into consideration admissibility is not in question. It can be used for collateral purpose, not as a. So that is our case, my lord. That because of this, because parties were in agreement.
Agreement of sale, when it is not relatable to part performance of contract,
yes,
is not required to be registered.
True. That is the amendment in Registration Act followed by the transfer of 53A. Right. I am not taking advantage of 53A. Otherwise, also there are perversity, my lord, but this juror relationship has come to an end with this agreement, and this judgment that has been relied upon.
Just give me the basic dates of the agreement.
Yes.
Agreement is dated.
First of all, a memorandum of understanding was executed, my lord. That is dated 3rd September 2007 with the original landlord. 2007. Exhibit A.
With original landlord. Exhibit A.
Yes. It is marked without objection.
Okay.
Then, my lord, Exhibit E, again marked without objection, is the agreement of sale. That is 30th October 2008.
Agreement 30/10.
30/10/2008.
2008.
Yes.
Okay.
Now this is then we made payment under agreement also 1 lakh, and thereafter we have proved those certain amounts.
1 lakh you paid.
With the agreement, and then my lord, other amounts.
Remaining amount.
It was a 35 lakh
Your
agreement.
willingness and readiness and.
Yes, always I am in suit, my lord. I am in a different suit. That is also recognized. Now that suit proceeds, I fail or I, but this relationship.
That's right. Then
yes,
there is an agreement, and you are in possession of
the property. Continue.
As per the agreement, you need not pay
that document. If we have enclosed, my lord, in the IA we have filed.
As per the agreement,
we need not require to.
Defendant was not required to.
Yes, my lord. That is in my IA. I have enclosed that, my lord. Page 35.
That's right. It's okay. We take your words.
No.
Pay rent.
Yes.
Okay.
Yes.
Now, thereafter what?
Now thereafter he died. Suit was instituted.
Okay. Landlord died.
Landlord dies in March 2009.
Died.
Sometime
in 2009.
Yes, I will give the exact date.
Okay.
And then September 10th March 2009 he dies.
Okay.
And his widow thereafter puts me a notice for eviction sometime in September 2000. I'm giving exact date.
Eviction under BBC Act.
BBC Act, my lord, under provisions for personal necessity and default.
BBC Act. Okay.
C and D.
So.
23rd October 2009.
23/10/2009. Then what happened?
Then my lord, then she immediately institutes this suit for eviction,
Okay.
and we also filed a suit for specific performance.
Okay, that is pending.
The amalgamated, now what happens, the amalgamation, the High Court said, no, these are two different proceedings, this will go differently. So then the trial court, without discussing any of this issue, if I take my lord, your leadership to this findings, nothing has, he has only quoted the provisions of the act. And he says once a tenant is a tenant, eviction granted. Neither a finding on personal necessity, neither a finding on default. I will place that. And then appellate court, when I come, again I agitated this issue of my agreement, because after entering into agreement a single rent, before that we paid. So there is no landlord-tenant relationship. So appellate court says that in view of section 17 of the Registration Act and 49, it is inadmissible piece of evidence, which is very peculiar. The evidence can be used for collateral purpose or other purposes, but it cannot be said to be inadmissible. More so, minus section 58 of the Evidence Act, once the document is admitted, it need not be proved. Here it is marked without objection.
No, merely because a document is marked without objection, that does not mean that the
But he has not denied.
proof is dispensed.
We have proved that content is also proved. Your Lordship, if finding, if your Lordship will have to look to it. So only for present while there is no finding. If I take trial court's judgment.
So then under such circumstances, how are the same substantial question of law involved? This is what was mentioned.
There was a case, Your Lordship.
This is what it was mentioned, that same substantial question of law is to be.
There was that case which my lord had framed on last occasion.
Yes.
There was a case that a sale deed was executed.
It was followed by a reconveyance deed.
Yes, it was.
Here is also a reconveyance. ऐसा तो कुछ नहीं. Then
Reconveyance.
how does it say that it is the same substantial question of law?
Jural relationship.
What do you mean?
End of the
कुछ भी बोल के mention करते हैं.
Sorry.
आप ही बताइए. You tell me that this substantial question of law is involved. Tell me this substantial question of law is involved.
Well, we say subject to your lordship, so kind pleasure.
गलत है ना. बताइए सर, mention करते समय इस तरह से नहीं करना चाहिए ना.
I'm sorry. He should have taken care of, but that is the point when we wanted to convey that aspect, because
when you say same, it's something which is very serious.
I tell you. Because after reconveyance in that matter, your Lordship, never rent was paid. In the earlier matter where my lord had framed the issue.
What is the period of default in this case?
Nothing has been examined.
No.
After 2009, but after agreement, that is the period of default. Because we have not paid any rent after the agreement. So that has been taken into consideration that we are in default. The plaintiff had set up a case that
क्योंकि हम ना इस तरह से substantial question of law frame नहीं कर सकते.
subject
क्योंकि same substantial question of law तो नहीं है. For sure.
reconveyance तो नहीं है इसमें.
तो सब तो वहाँ नहीं है. You have to place the case. You place your case.
Yes. I'm just. Case is like this one, that I was a tenant under the plaintiff's husband.
Yes.
Who admittedly I was a tenant under him, and thereafter, as I have stated, that we entered into a memorandum of understanding with husband of the plaintiff, followed by an agreement, that is Exhibit A and Exhibit E. Now, after death of the landlord, the wife of the landlord institutes a suit after putting me a notice, which we have also replied, and then based on that, and the suit of the plaintiff is precisely if that and we have taken that 15,000 was the monthly rent. We have said that it was a rent of 3,500. We have also brought on record the rent receipts. Now, trial court.
You paid rent up to which date?
Till 2007. If I just take.
As per the case of the plaintiff, you defaulted since 2003.
She says.
Yes.
She says.
What is the finding?
Finding, that is, I am just, if I, Page 50, that is I am placing it. If I just place one page from page 50, that is the reflection of the case of the plaintiff. Third, the defendant counsel first. He submitted that the problem, because defendant was inducted as a tenant in respect of the suit premises at the rate of 3,500 per month on 15/1/2001, and he paid rent to Satyendra Kumar Sinha. Satyendra Kumar Sinha was the owner of the suit property. He entered into the agreement for sale of the suit premises with the defendant for a consideration of 35 lakhs. The defendant paid rupees 1 lakh through account paid check in favor of Ajit Kumar Sinha. The attorney holders of the Satyendra Kumar Sinha executed an agreement for sale on 30/10/2008 in compliance of memorandum of agreement dated 30th September 2007, and it was agreed to sell that sale would be performed on or before 3/9/2010. The defendant has been occupying the suit property in continuation of the part performance agreement of sale. Satyendra Kumar Sinha died on 10/3/2009. Defendant requested the legal heir of Satyendra Kumar Sinha for performance of sale deed, but she refused to perform the sale deed and started to the defendant. The defendant is ready to perform her part of agreement with title suit number so and so. There is no relationship of landlord-tenant between the parties. There is no default in payment of rent because after payment of huge amount of certain amount, the defendant has been occupying the suit property in scope of part of one. There is no need of suit premises to the plaintiff. No legal notice has been received by the defendant. The plaintiff has settled in Siwan prior to November 2008. The defendant had been paying rent to the house owner regularly. The suit required to be kept pending under 53 of the transfer property. The suit has been filed by the plaintiff with malified intention. The suit property has been may be sold to some other at higher rate. These are the judgment then quoted by. Now issues being discussed. Issue 3, 4, 5. As per 2F, 3, 4, the issues are framed at page 48. Right? Includes person who for time being receiving.
You read the issues.
Yes, Violet. Page 48. Whether the suit is claimed as maintainable, has plaintiff got valid cause of action for the present suit, whether Satyendra Kumar Sinha, husband of plaintiff, inducted defendant as a tenant in respect of the suit premises on monthly rent of 15,000, and after death of Satyendra Kumar Sinha, the plaintiff being widow inherited the property as owner.
You are on issue number 7.
Issue number 7, whether the agreement or the defendant was not required to pay rent. Yes.
Where is it? Where is the finding?
Yes. So, finding comes page 55, issue number 6 and 7. The fact of payment of 35 lakh to certain by the defendant under agreement of sale is a matter of fact in title suit, and the court has not gone into jurisdiction to embark on this point, and hence the court restrained himself to comment on the point. The matter of agreement of sale property between Satyendra Kumar Sinha and defendant is so and requires no comment by this court.
Where is the finding on default?
Yes, default issue is coming my spreadsheet with the
3, 4 and 5.
3, 4 and 5. Yes, I'm just coming to that. So it is taken at page 51, 3, 4 and 5 simultaneously. Now the provisions of the act is dealt. If
The defendant admitted.
Yes, from there, defendant admitted in written statement that he was inducted to month tenant with respect to the suit premises. Satyendra Kumar Sinha inducted the defendant as tenant on 15/1/2001. The plea of that is that he entered into an agreement with Satyendra Kumar Sinha to purchase the suit premises for consideration of 35 lakh. He paid advance money to Ajit Kumar Sinha, who was the attorney holder of Satyendra Kumar. 1 lakh was given on 8/10/2007. Agreement was executed on 30/10/2005. Satyendra Kumar Sinha acknowledged receipt of 1 lakh. He further took rupees 4 lakh from the defendant. Defendant files the title suit so and so, claiming decree of his specific which is pending in the court. Now quoting provisions of section 11 which relates to the eviction. Coming on to page 53, that provisions of law are being quoted there. Then finding is written at page 54 of the court.
Page 54.
Yes. Last part, the defendant, when the just penultimate, the plaintiff has claimed the suit premises for eviction on the ground of personal necessity and default in payment. The defendant has already admitted in the statement that he was inducted as a tenant by Satyendra Kumar and he has paid rent at the rate of rupees 3,500 per month. he stopped payment after entering into the agreement with Satyendra Kumar Sinha. Now the question arises whether the present suit and the suit filed by the defendant against the plaintiff therein title should be considered together. The matter was already heard by the court and the court passed order that both the suits are different and the prayer for defendant to hear and decide both the cases together was rejected. The Honorable High Court passed order directing trial court to dispose of the trial in 6 weeks. When the two cases are different and in the present suit relationship of landlord-tenant has already been established, including the fact that defendant defaulted in payment of rent. Now there is no finding. Jumping to this conclusion, neither evidence has been discussed. Default finding has been given 3, 4, 5. After quoting that one paragraph was there initially, your leadership, and then this is the finding that is written.
What happened to the specific performance?
It is pending, madam.
What is the stage?
Stage. I have to take instruction from the client because evidence were going on.
This agreement of sale dated 30th October 2008.
Yes. That we have brought on record by IE. And if you may be seeing, we have paid rent in 2007.
What is the finding of the first appellate?
Yes, first appellate court judicial will find point of determination is at page 28. Paragraph 10, page 28. Internal page 10 of the
Page 28.
8. That is whether in view of the alleged unregistered agreement to sale in favor of appellant there subsists any relationship of landlord and tenant between the respondent and appellant. Then after discussing, because there was also a case set up that 15,000 was the rate and rent receipts that we have brought, that was 3,500. Now the finding party, after discussion, leadership will find this is page 17 onwards, page 32, 50. Yes. Para 18 में भी से, para 17, page 35.
Para 70?
Yes, para 17. Yes. The appellant has disputed the landlord-tenant relationship between the husband of the respondent and himself on the strength of a non-registered agreement. However, a sale agreement is compulsorily required to be registered, and if the same is not registered, then as per section 49 of the Registration Act, it cannot be received as evidence of any transaction affecting such property or conferring such property. Though it may be received as evidence of a contract in a suit for a specific performance under Chapter 2 for a specific legal. In above position, The unregistered agreement exhibited cannot be read in evidence in present proceeding. According, in absence of evidence, the relationship of respondent and appellant remained as that of landlord-tenant. In above view of the matter, the ratio of judgment of apex court is not applicable in the present case. There was also a case of unregistered agreement.
Where is this citation?
Yes, 2000. Yes. If a place when a small judgment if a place is valid in entirety, 2-3 paragraphs. Or
First the question, whether on the execution of the agreement of sale
Yes.
by landlord with the tenant.
The, landlord with the tenant and landlord having received substantial portion of the sale consideration, the relationship of landlord-tenant interest between them ceases and fresh right and obligation flow under the agreement.
This is a case where substantial consideration was already received.
But your ladyship,
You have paid only 1 lakh.
no, 5 lakh. I mean 5. If it's out of 35. But if my your ladyship,
You read it further. Read it further. Paragraph.
Yes. The present appeal is by tenant who received decree of eviction against him by order of the trial court confirmed by the appellate court and finally affirmed by the High Court. The respondent landlord filed the suit for eviction on the ground of willful default and also committing an act of waste under section 10(2) and 10.
Specifically back.
2(3) of the Tamil Nadu Building Lease Rent Control Act 1960. Here, her case is that though the tenant paid rent regularly up to March 1977, but thereafter did not pay rent regularly, but on request of the appellant tenant to the landlady, she agreed to sell the disputed premises. As a consequence, the agreement of sale was executed on 4/5/1977. According to the landlady, a breach was committed by the appellant. Hence, she repudiated the agreement by returning the amount she received under it, and then she filed a suit for eviction against the tenant. It is not in dispute that in terms of the said agreement, total sale consideration was 25,000, out of which this tenant paid 20,000 to the landlady on the date of agreement itself. The balance 5,000 remained to be paid on the date of registration of the sale. Relying on the agreement of sale, the appellant's case is that on its execution, the relationship between respondent and appellant changed. They no more remain as landlord and tenant. Hence, the present petition for eviction under the aforesaid act is not sustainable. In the alternative, it is submitted that in any case, non-payment of rent for the period cannot be constituted to be a willful default within the meaning of section 10 of the aforesaid act. The rent controller and the appellate authority both rejected this contention of the tenant and held that the tenant committed willful default, which was confirmed by the High Court. As aforesaid, the question for consideration is whether the status of tenant as such changes on execution of an agreement of sale with the landlord. It is relevant at this junction first to examine the terms of the agreement of sale. The relevant portion of the agreement of sale reports as following: I, the aforesaid so and so, agree out of my own free will to sell, convey, transfer the property so and so to this so and so.
You got to para 7.
Yes, para 7. Yes. This court in Arjun Lal Bhatt so and so held as under the appellant were tenant in the premises of the respondent landlord, and 3 suits, including eviction suits, were pending against them. By the agreement between the appellant and the respondent agreed to sell the whole property to the appellant for a certain sum to be paid by him in equal installment. Clause 5 of the agreement provided that in case of default of any installment, the agreement for sale would be cancelled, and if the purchaser failed to pay the defaulted installment within 1 month, notice the payment made would stand forfeited, and purchaser would make over the possession of the property to the vendor. Under Clause 5 of the agreement, the question of giving notice arises only if the vendor wanted to forfeit the installment paid by the purchaser. Not even one installment having been paid in question of forfeiture does not arise, and no notice was necessary for cancelling the agreement. It is stood automatically cancelled. It was sought to be argued before us that once the agreement is stood cancelled, the appellant is stood restored to their original position as tenant, and the suit could not be filed without giving notice under Transfer of Property Act. We are of the opinion that when the agreement dated so and so was entered into an old relationship of landlord and tenant came to an end, the right and liabilities of the parties have to be worked out on the basis of that agreement. This decision clearly spells out that once there is an agreement of sale between a landlord and tenant, the old relationship of such comes to an end, it goes on to record that even after such cancellation of such agreement of sale, the status of the tenant is not restored as such. In other words, on the date of execution of the aforesaid agreement of sale, their status as that of landlord and tenant changed into a new status as that of a purchaser and seller. Thus, within the legal premises, the submission by learned counsel for the respondent for revival of the old relationship of landlord and tenant whence he repudiates the agreement by sending back the tenant rupees 20,000 through a check, which according to the appellant was not encashed, cannot be accepted, so we have no hesitation to reject the same. Every conduct of the landlady right from the date of entering into agreement of sale, accepting money towards the sale, consideration, delivery, possession in lieu of the agreement, all clearly indicates that and has to be construed in law that she repudiated her old relationship of landlord-tenant. Thus, after the parties enter into a new cloak of seller and purchaser, their obligation is to be governed under the.
Is there any corresponding provision under the Specific Relief Act 1963?
Regarding
This corresponding to Chapter 2 of Specific Relief Act 1877. Do you have any idea? SC number 72 of 2025. This appeal has been filed by SC number. The learned counsel for the appellant has submitted that a suit was filed seeking eviction on ground of personal necessity and default in payment of rent. And the suit was decreed. So far as the learned first appellate court is concerned, the judgment passed in the suit was affirmed. He submits that a memorandum of agreement understanding was entered into between the original landlord and the appellant on 3/9/2007, and ultimately an agreement of sale with respect to the suit property in which the appellant was a tenant was entered into on 30/10/2008.
Exhibit E.
Exhibit
A and E.
Exhibit E.
First is Exhibit
And
A.
as per the agreement dated 30/10/2008, read with the memorandum of understanding, the appellant, the dependent was not required to pay rent after 3/9/2007. Rent after September 2007. The learned counsel submits that on account of clear stipulation in the agreement of sale, the relationship of landlord and tenant ceased between the parties. However, before the sale, the agreement of sale could culminate in a sale deed. The landlord died in the month of March 2009. And after the death of the landlord, his wife instituted the suit seeking eviction.
6 months thereafter. Original landlord never put me to any notice.
The suit was filed on 23/10/2009.
Okay.
He submits that in the meantime, the defendant of the present case also filed a suit for specific performance of contract, which was title suit number
Yes.
title suit number 474 of 2009. Correct?
Correct.
He submits that the title suit is still pending. The prayer to amalgamate both the suits was rejected by order dated 3/12/2014, and the order was confirmed by this court in writ petition being WPC number 5064 of 2015, and consequently both the suits proceeded separately. The learned counsel submits that while reversing the judgment of the learned, while affirming the judgment of the learned trial court, the learned first appellate court was of the view that the agreement of sale being unregistered could not be looked into, and the same could be considered only in a suit for specific performance of contract. And therefore refused to read Exhibit E, the agreement of sale, into evidence in the proceedings. The learned counsel submits that the agreement of sale per se is not compulsorily registrable. The question of its registration comes only when a person wants to rely on the document and under section 53 capital A of Transfer of Property Act. The learned counsel submits that a substantial question of law arises on this aspect of the matter. After hearing the counsel for the appellant, this appeal is admitted for final hearing on following substantial question of law. Whether the learned first appellate court, by reversing the judgment, was justified in refusing to consider Exhibit E on the ground that Exhibit E, the agreement of sale, dated 30/10/2008, on the ground that it was an unregistered agreement. Roman 2. If the answer to the aforesaid question is found in favor of the appellant, the following further substantial question of law would arise. Whether the defendant appellant can be said to be a defaulter in payment of rent नहीं, मैं समझ गई. Whether the appellant ceased to be a tenant.
It can be, yes, but it can be said to be a willful defaulter because there was an agreement.
आपका पर्सनल नेसेसिटी तो आपके अगेंस्ट
नहीं,
में
तो
है.
personal trial court has not discussed anything personal necessity.
Okay, there is no finding on personal
It might not
necessity.
only discussing the provision and then jumping to the conclusion that he has said so it is a personal necessity.
No. What I want to say.
But
is,
first appellate court has
if the relationship exists,
yes.
तो डिफॉल्टर नहीं होने पर भी तो आपका
Independently personal independently every ground is there.
Right.
Yes.
ऐसे देखिए, whether the relationship of landlord and tenant continued in spite of the agreement dated 30/10/2008, and if the answer to the aforesaid second substantial question of law is found against the appellant, whether the learned courts were whether the appellant can be considered to be a defaulter Willful defaulter is the word used.
Yes, that is Supreme Court says because there is an agreement. So under genuine belief.
I think
First
these
question,
two questions.
yes.
These two
I
questions will be
agree.
sufficient.
I go down.
Yes. Issue notice to the respondents. कौन है respondent?
Respondents are there, मैंने.
सिर्फ दो ही question. Who is the respondent?
Respondent is Srimati Krishna Sinha. That's the only sole respondent.
Under post, for which requisites be filed within a period of 1 week from today, office to fax be posted.
There was one.
Post this case on 7th October. Yes.
7th. So IU will be considered on that.
इसमें मेन अपील में एज वेल एज ऑन द इंटरलोक्यूटरी एप्लीकेशन सीक्वेंस दोनों में नोटिस है.
Yes.
Careful, mister. No two cases are identical, as no two persons are identical. हाँ, call for reference. Special messenger cost, वो भी आप
Grateful.
अब आ जाएगा तो डिसाइड करेंगे.
नहीं होना उस पे भी हम लोग ready. That is running on board. That's second matter. But since my lord is hearing so many cases, civil consumes time. Grateful.
ये रखें.
Grateful.
ओके, एक चीज और लिखिए. उसमें अपील हो गया डिसाइड. देखिए तो सेकंड अपील नंबर 129 ऑफ 2022.
Yes.
डेट कब है उसमें?
डेट अभी
बिना डेट के तो कोई केस नहीं होता.
एक डेट आया तो उसके बाद दो डेट और डेट. यस.
सेकंड अपील नंबर 129 ऑफ 22 का डेट किस? सितंबर. अभी हम इसको कौन सा डेट डालें? 15 सितंबर को जब ये मैटर आएगा ना,
तो
अभी 7 अक्टूबर को
7th October.
उस दिन 15 सितंबर को जब ये मैटर आएगा, either we decide that matter and if there is any date, next date in that matter, then it will come on 7. ठीक है?
Good.
ध्यान रखेंगे सभी चीज.
Good.
Household case item 6, second appeal 189 of 2003.
ये पास ओवर है. कहाँ है आपकी मैटर? ऑर्डर्स में है ये. ऑर्डर्स में केस नहीं बताया. Respondent number? थ्री का कोई सब्स्टिट्यूशन पिटीशन नहीं फाइल हुआ और रेस्पोंडेंट नंबर 2 के अगेंस्ट तो अबेट ही कर दिया.
पिटीशन फाइल किए लेकिन वो लोगों से पूरा भी कर दिया.
आपने इन्फॉर्मेटरी पिटीशन फाइल किया. 11 कब आपने फाइल किया? 11/4/25, right? And when did he expire? Respondent number 2. Date बताइए.
6/3/20.
6/3/20.
5.
देखिए जरा. Nobody appears on behalf of the appellant in spite of repeated calls. The counsel for the respondent submits that the respondent number 2 had expired on 6/3/25 and an informatory petition to that effect was also filed before this court on 2/4/2025 giving the details of all legal heirs and successors. But no petition for substitution has been filed. He submits that the proceeding has abated as against respondent number 2. Right? Considering the posted submissions, the proceeding stands abated as against respondent number 2. Next, the learned counsel, the records also reveal that on 3/4/2025, it was reported that respondent number 3, namely Ranka Orang, has also expired, and the matter was adjourned at the instance of the appellant. Thereafter, the matter was taken up on 17th of July 2025, and by way of last indulgence, 2 weeks' time was granted to take steps for substitution. The counsel for the respondent has submitted that the records reveal that no substitution petition has been filed. Considering the aforesaid, he has also submitted that the proceeding has abated also against respondent number 3. Considering the aforesaid submissions, this appeal stands abated as against respondent number 3 also. अब बताइए बहस करेंगे आज नहीं किसी दिन, क्योंकि ऐसे नहीं डिसमिस करते हैं केस, अगला दिन में नहीं आएंगे तो डिसमिस करते हैं, ऑर्डर्स में लाके केस डिसमिस नहीं कर सकते. The records also reveal that the case has been adjourned on repeated occasion upon payment of cost. Office is directed to place this case under appropriate heading on next Tuesday.
From supplementary this case item 1, first appeal 3/6 of 18 allow the cases.
IE number 12479.
Like I कितने लोगों का सब्सक्रिप्शन है? कितने लोगों का सब्सक्रिप्शन है?
Explain here.
डेट तो बहुत सारे हैं. आपको कोई ऑब्जेक्शन है?
No,
सबका वकालतनामा मिल गया आपको?
I'm collecting. छुट्टी में I'm plan कर रहा हूँ. आ गया कुछ बहुत सा आ गया, कुछ मिसिंग है, आ रहा है. ऐसे हम अंडरटेकिंग की क्या उनके बिहाफ में हम अपियर करेंगे. सबमिटिंग में अंडरटेकिंग. मेरा वकालतनामा तो ऑलरेडी मेरा उस पर भी पड़ा हुआ है. इन माय अपील्स. सिंपल.
उससे क्या होगा? उससे इसको थोड़ी कनेक्ट कर देंगे. मन नहीं है आपको ये केस करने?
नहीं करने कर देंगे. कुछ कम मिला है, इसलिए हम चाहते हैं जब कंप्लीट हो जाए.
नहीं चाहने से नहीं होगा. आपका वकालतनामा होता तो हम सब्स्टिट्यूशन अलाउ कर देते. बिना लीगल हियर को नोटिस किए कैसे सब्स्टिट्यूशन अलाउ करेंगे?
इनका 3 पिटीशन है, 3 आईए फाइल करेंगे. उसमें सब में एक साथ ही हम कंपाइल करके फाइल करेंगे, क्योंकि बैच वाइज कर रहे हैं. तो हम अंडरटेकिंग लेंगे कि आई विल फाइल 3 ईच एंड एवरी. तीनों एक साथ करते हैं फाइल, अब तीनों कर देंगे.
और नाम सब मैच करके डालेंगे.
हम नाम मैच करेंगे, पर वो बार इस मेटिकुलसली मिला
आपने
दिए.
तो सब मैच करके डाला होगा इसमें नाम. इसमें कुछ एरर है नाम में?
नहीं, सब जो हमको मिला था
मिला है वही है सर.
सॉफ्ट कॉपी से
आफ्टर वेरीफाइंग फ्रॉम द डॉक्यूमेंट्स इसमें 4 लोगों का डिलीशन है और बाकी का सब्स्टिट्यूशन.
किसका डिलीशन है?
respondent number 99, 100, 101, 130.
एक ही साथ करेंगे ऑर्डर। आप बाकी सब कब तक फाइल करेंगे?
नेक्स्ट के नेक्स्ट वाले वीक में मैंने जैसे till yesterday my lord I have collected all the information I have sent it for meeting my lord they take at least 1 week
That's next के next week फाइल करेंगे।
my lord.
IE number 12479 of 2025 in FA number 367 of 2018. The counsel for the parties are present. This petition has been filed for substitution of a large number of persons, a large number of respondents. The learned counsel for the appellant has submitted that these respondents / their predecessor in interest have filed separate appeals. They are party in different appeals which are tagged along with this appeal. And in the said appeals, they are the appellants. They have submitted that the substitution has already been allowed in the respective appeals. The learned counsel for the respondents in FA number 367 of 2018 and appellants in the other connected appeals has submitted that he has received instructions to appear on behalf of the proposed legal heirs and successors, and he further submits that if permission is granted by this court, he shall file wakalatnama. Permission is accorded. आप बस वेट मत करिए सबके फाइल
चाहते कि तीनों बैच इनका फाइल कर
नहीं
दें?
नहीं चाहने से नहीं होगा। आप इसका फाइल कर दीजिए
Okay,
क्योंकि ये तो केस हर हफ्ता लगेगा।
ठीक।
अगला हफ्ता में इसमें जो जो आप फाइल कर देंगे आप सब फाइल कर दीजिए। इसमें तो आ गया होगा आप तो बस आप फाइल कर दीजिए, ठीक है। पोस्ट ऑन नेक्स्ट वीक। आज है वेडनेसडे। आज वेडनेसडे है।
Yes.
नेक्स्ट वेडनेसडे इस बीच आप फाइल करिए।
Soft copy I have given the details.
हम खुद मॉनिटर करते हैं सब। सॉफ्ट कॉपी रहने से कोई एरर का चांस नहीं है। पार्टी पोजीशन हम लोग बना रहे हैं क्योंकि वो भी एक बहुत बड़ा काम है।
उस सब कनेक्टेड आपको मिली थी सब।
हाँ सब ये चीज़ अभी भी सब उसके अलावा नोटिस किया गया।
ऊपर ठीक से लिखिएगा कौन रेस्पोंडेंट की तरफ से आप अपीयर हो रहे हैं। आपके राइटिंग बहुत छोटा छोटा नहीं, ऊपर वकालतनामा के ऊपर एकदम सही से लिखिएगा किसको किसको अपीयर करना है। अगर अच्छा होगा वकालतनामा में नाम रहेगा और साथ में एक एडिशनल पेपर लगाकर
सेपरेट शीट में लगाकर
एज पर सेपरेट शीट उसको करके फाइल करिएगा तो ऑफिस को भी वेरीफाई करने में सुविधा होगी, ठीक है।
कैरी आउट
हाँ आइए पेंडिंग है।
आज का ये पेंडिंग
आइए पेंडिंग रहेगा। कैसे अलाउ करेंगे इनका वकालत नहीं तो सबको नोटिस करना पड़ जाएगा हमें।
नहीं ना अभी है वकालत
नोटिस हो गया तो मतलब साल भर उसके बाद 2-4 लोग और मर जाएंगे। बस हमको इसी बात का चिंता है कि अब और किसी को मरने नहीं देना इस रिकॉर्ड में बिफोर आई डिसाइड दिस केस।
From query list for admission item 32, first appeal 137 of 2025.
Yes,
This is a first appeal against order for apportionment which was allowed in favor of the plaintiff respondents.
formal admission.
Yes, Lordship. However, there is an IA for stay of disbursement of award.
आइए पर
IA for stay of the disbursement of awarded amount. Lordship.
who is for the state? State must be here. स्टेट नहीं है इसमें पार्टी।
नहीं, Lordship, state party.
इसमें लैंड किसके लिए कर
Lordship, NHAI में acquire हुआ है
So
for
NHAI is not a necessary party. Yes. NHAI was not there before the court.
Lordship, verify कर
Yes. NHAI की तरफ से कोई evidence नहीं है.
Lordship, NHAI नहीं था नीचे वाले कोर्ट में
In reference cases when they are not parties, the person who has acquired the property.
Lordship, पहले रेफर हुआ था फिर प्लेंटिव डायरेक्टली आके अप्रोच किए कि बेस्ड ऑन द सेट रेफरेंस वी हैव फाइल्ड दिस सूट फॉर अपॉर्चनमेंट बट दे हैव नॉट बीन मेड अ पार्टी बाय द प्लेंटिव
आपको सही लगा ये?
By rule, only acquisition officer and the concerned departments are made a party
Unnecessary, unnecessary.
because they have to also get a
Disburse कौन करेगा? इसका तो execution file है ना?
yes sir Lordship.
क्या disbursal का?
IA फाइल के अंदर Lordship IA नंबर 554 of 25
Execution case डाले हैं इसमें.
एग्जीक्यूशन केस नंबर अभी पड़ा नहीं है Lordship एप्लीकेशन डला चुका है लेकिन अभी तक कुछ ऑर्डर रिगार्डिंग एक्सेप्टेंस ऑफ एप्लीकेशन हैज आल्सो नॉट बीन मेड बाय द एग्जीक्यूटिंग कोर्ट
वो institute नहीं करता.
Lordship, it has been instituted, but no order has been passed, not even about regarding the institution of case or filing of application for disbursement. Nothing has been made on order right now.
तो आपके पास कुछ नहीं है, कुछ हो ही नहीं रहा.
Which will find a supplementary to that idea. Lordship.
फिर आप थोड़ा इसमें देखिए कोई फॉर्मल पार्टी किसी को एडिशन ऑफ पार्टी भी हो सकता है फर्स्ट अपील स्टेज में. Figure it out.
Yes, sir, Lordship.
I just do not know whether they are necessary party. They are. कौन से प्रोविजन में फाइल किया?
Lordship, section 96 of CPC was
इसमें ये भी काटा हुआ. कौन काटा है इसे?
defect to point of one था, but
तो ignore हो गया.
that was not a defect, Lordship. क्योंकि
That
problem
was not.
that was not a defect, Lordship. क्योंकि apportionment को लेके हम लोग यहाँ हैं, तो in that case under section
The
96
by and the put a cross over there.
इसका defect भी remove नहीं किए थे, Lordship, and all defects have been complied with, so no objection in that regard is being raised by you.
AP number 137 of 20. Admit. Call for the records from the concerned court. Let notice be issued to the respondents for which requisites be filed. Under speed post as well as ordinary process within a period of 1 week from today.
Regarding the IA submit, award has been prepared, award numbers are there. Now only the petitioner, plaintiffs have to file the representation and withdraw the award. No execution case.
हाँ तो पार्टी नहीं है कोई हम किसको क्या डायरेक्शन देंगे? मुश्किल है बहुत मुश्किल है. आप आइए में भी कुछ पार्टी नहीं बनाएं किसको हम लोग डायरेक्शन देंगे? और अगर डिग्री हो गया कोर्ट का ना तो एग्जीक्यूट ही होगा, ऐसे डायरेक्टली कोई डिसबर्समेंट नहीं होगा।
और स्टेट को मनाने का कुछ इंस्ट्रक्शन दे देते हैं।
आप देख लीजिए किसको पार्टी बनाना है, स्टेट होगा या NHAI होगा, आई डोंट नो। कहीं को मान लीजिए डिसबर्स हो जाता है, यहाँ पे कुछ ऑर्डर हो जाता है, हम कहाँ से रिकवरी करेंगे? एंड एटलीस्ट यू शुड इन्फॉर्म द अथॉरिटी that such and such appeal has been edited, the records have been altered. If you do that, ये पैसा निकल जाएगा आपके हाथ से, लग रहा हमको ऐसा।
Also, we'll file the supplementary as well.
अब जो भी करना है ये फाइल करना पड़ेगा, सप्लीमेंट्री फाइल करना पड़ेगा। Yes sir. In case, Mr. Sai, in case of land acquisition, when there is a dispute of disbursement of apportionment, the person for whom the land has been acquired is a necessary party.
But in fact, he is the payer of the
Yes.
price
he is
of the
a-
property.
Yes.
and when
Enhancement का plea नहीं है, apportionment का plea, वो भी तो वो necessary
it
party
is
है।
became the under the new act, my lord. Section 64 is the provision wherein the land acquisition officer, district land acquisition officer, refers the matter himself
That's
to the
right.
honorable district judge.
That's right.
Bas.
But
And
the
there it
person,
will be decided
and then
who
how
will
it
get.
will be executed?
My lord, if it is apportionment,
Yes.
then district judge will decide. And if it is the price of the property,
No, enhancement का case नहीं।
नहीं.
Enhancement में तो वो necessary party है, there is no doubt. But in case of apportionment,
हाँ.
they are not necessary party.
Well, in fact,
I don't know. Let's see. We just
tomorrow I will give a judgment. I have seen recently. District
दे
judge
दीजिएगा, थोड़ा सा
has been given,
समझना होगा इस चीज को।
हाँ,
They are
has been given all power. Under section 64, he is the district judge and the act has reposed all
Anyway, we are
confidence.
posting it on Sunday, 14th October. Post on 14th October.
Generally, the state goes to the district judge and says that apportionment should be in this manner.
Let's.
For hearing under order 41 rule item 33 second appeal 538 of 2016.
अच्छा इसी में टाइम मांग ऐसे नंबर 558 of 2016. Date 17. At the request of the council for the appellant, pose this case on 17. 17 तारीख.
Item 34 second appeal 291 of 2017.
Appellant. Where is the appellant? Essay number 291 of 2017. The appeal was lastly taken on 28/11/2024. and by way of last chance, prayer for adjournment was allowed to advance arguments in the matter of admission. Nobody appears on behalf of the applicant. No advance notice has been circulated seeking adjournment. कहाँ है रिकॉर्ड का तो कॉपी आज नहीं है. In order to give one more chance to the applicant, pose this case on 24th, subject to payment of cost of rupees 5,000 for clerk association. The receipt regarding cost will be filed before this court by 19th of September, failing which the subject shall stand dismissed without prejudice.
Item 25, second plea 315 of 2017.
Who is there? SA number 315. Please, madam. Adi.
My lord, this is a very peculiar case. Here I have lost the case right from the executive magistrate to the SDM, to the AC, to the division commissioner, to the civil judge and to the district judge. And here I have come as a last option, my lord. यहाँ मैटर ऐसा है my lord कि हम लोग एक जो है एक संस्था है अंजुमन इस्लामिया. We have purchased the land of 4 decimal for the construction of the masjid. जो जिससे हम जमीन लिए हैं my lord, वो एक लेडी है मंतो देवी. मंतो देवी वाले मुसलमान शिवाजी बीरो. अब उन लोगों के बीच में आपसी बंटवारा हो चुका था क्योंकि उसका जो भैंसुर है ग्राम सेवक my lord.
Registered deed है.
रजिस्टर्ड डीड है
ये आपने खरीदा था registered deed से.
my lord.
डेट बताइए.
क्या है एक 4117 dated 20 September 74. हमने खरीदा मंतो देवी से शिवाजी मुसलमान. तो उसके बाद क्या होगा जब हम बनाने के साथ क्या मेरा म्यूटेशन हो गया. जब हम बनाने लगे तो कुछ वहाँ कॉमन फीलिंग हो गई कि यहाँ मस्जिद कैसे बनेगी जबकि वो लैंड जो है मुसलमानों के बीच का है.
इससे कोई मतलब नहीं.
कोई मतलब नहीं हो मैडम. तो उसके बाद क्या है कि उसको कहा विधि व्यवस्था की समस्या हो जाएगी. तो केस चला गया एग्जीक्यूटिव मजिस्ट्रेट के, वहाँ भी लंबा चला. फिर केस चला गया एसडीएम के यहाँ, फिर केस चला गया एसी के यहाँ, केस चला गया डीसी के यहाँ, केस चला गया कमिश्नर के यहाँ. उसके बाद हम हाथे चले गए. उसके बाद हमारा ये कहना है कि उसमें एक उन लोगों का आरोप ये है कि उसकी एक बेटी थी सुलेखा कुमारी
मंटो देवी
की. जी She was the
Sulekha
only son.
Kumari.
Sulekha, she was a minor.
At the time of execution,
Minor.
appropriate permission मिला?
तो उसके बाद क्या है कि उसको उसका दस्तखत इसलिए नहीं हुआ किसी वजह माइनर है
दस्तखत तो नहीं होगा, लेकिन उसका प्रॉपर्टी बेचने के लिए परमिशन तो होगा।
माय लॉर्ड, बड़ी इम्पोर्टेंट बात यह है कि सुलेखा कुमारी की ओर से कोई ऑब्जेक्शन नहीं है।
सुलेखा कुमारी
जो उसकी बेटी है मंतो देवी की, कोई ऑब्जेक्शन नहीं है। और कहीं भी हमारा रजिस्टर्ड सीट सेल को कैंसिल करने का कोई भी आवेदन नहीं है। नो सूट इज पेंडिंग फॉर द कैंसिलेशन ऑफ द सेल डीड। दैट इज वेरी इंपॉर्टेंट माय लॉर्ड।
देन
और सारा केस ये चल रहा है कि वहां रामनवमी मेला लगता था, ये इसी पर है माय लॉर्ड। उसमें 1 to 10 जो उराव लोग हैं उन लोग कहता है कि हम रामनवमी मनाते थे, और बाकी जो 11 से 15 लोग हैं दे आर द डिसेंडेंट्स ऑफ द रामसेवक साहब, जो मंतो देवी की भैंसुर के बेटे हैं। तो ये कहानी हो गया। उसके बाद हमारा ये कहना है कि ये जमीन जो पहले थी खतियान में वो शेख हावड़ा के नाम से थी, शेख हावड़ा। और शेख हावड़ा वाली मुस्लिम, और वहां लिखा हुआ है घर बागी। इसका मतलब है कि इसके बिकने से पहले वह घर बागी था, तो खाली जमीन नहीं थी, तो मेला लगाने का तो क्वेश्चन पैदा नहीं होता। मैं पहली बात ये है। अब उसके बाद से उस जमीन को बुच्चा साहब खरीदा। बुच्चा साहब इज द ससुर ऑफ मंतवा देवी। फिर अल्टीमेटली वो जमीन को अंजुमन ने खरीदा। तो कहीं भी मेला लगाने की बात नहीं है। अगर मेला लगता माय लॉर्ड तो उसका लाइसेंस होता, उसका अखाड़ा का लाइसेंस होता, बट्टी वसूली जो होती है मेला में उसका रसीद होता। तो मेला लगने की बात जो है ये किसी भी तरह से साबित नहीं होती, इसके पक्ष में कोई सबूत नहीं दिया गया। और माय लॉर्ड, हम चाहते हैं, अब मस्जिद मेरी बन गई है, अब हम चाहते हैं स्कूल बने, उस जमीन को हम स्कूल में यूज करना चाहते हैं।
मस्जिद तोड़ के
नहीं, मस्जिद कहीं और बन गई,
हाँ?
कहीं और बन गई मस्जिद। इस जमीन में मस्जिद नहीं बनने दिया गया, तो मस्जिद कहीं और बना दी है। ये जमीन रह गया डिस्प्यूट में, तो हमको स्कूल यहाँ बनाना है। और हमारे टाइटल के खिलाफ में कहीं भी कोई आवेदन नहीं है। टाइटल इज नो वेयर चैलेंज। सुलेखा कुमारी की ओर से भी कोई चैलेंज नहीं है। बहुत ही टिपिकल केस है हमारे।
Sulekha Kumari is a party in this proceeding.
No, she is not. सुलेखा कुमारी का भी डेथ हो गया, उसका एक बेटा बचा हुआ था, तो बेटा का भी डेथ हो गया। उसकी एक विधवा बेवा है विमला देवी, शी इज सर्वाइविंग ओनली एंड शी इज नोवेयर इन दिस पिक्चर। इस लड़ाई में कहीं नहीं है बेचारी। हर जगह हाथे आ रहे हैं हमारे। देयर इज नो चबूतरा। ये ऑब्जर्वेशन है कोर्ट का। मेला लगाने का, झंडा बांधने का कोई चबूतरा नहीं है। मंदिर में बैठाने का, मूर्ति बैठाने का कोई चबूतरा नहीं है।
आपका सूट इज नॉट मेंटेनेबल बोल रहे हैं।
My lord, हम
आपकी कहानी कुछ भी हो, but if it is not maintainable on some technical ground, right?
My lord.
How can it be entertained?
My
The
lord.
suit has been held for non-compliance of the provision of a representative suit and for non-joinder of necessary party and improper framing of suit.
My lord.
टेक्निकल ग्राउंड में आपका बहुत बढ़िया केस होगा, लेकिन टेक्निकल ग्राउंड में अगर सूट डिसमिस्ड है तो उसका हम लोग क्या करेंगे?
My lord, उन लोगों के बीच में बंटवारा हो चुका था, अगर हम बेचे या गलत किए।
आप मेरिट पे मत आइए, पहले जो टेक्निकल ग्राउंड में आपका जो सूट को नॉट मेंटेनेबल बोल दिया है, इसका पहले जवाब। आपको अभी एंट्री टिकट नहीं मिला because the suit has been held to be not maintainable. If the suit is not maintainable, you may have, you see, please appreciate, if the suit is found to be not maintainable, that does not mean that you cannot file a fresh suit because on technical ground it has been held is not maintainable.
Madam, all right, madam. I got the point.
तो इसको लड़के आप क्या करना चाहते
नहीं, my lord, I
हैं? Are you
will.
serving your litigant?
My lord, I
आप
pray.
सोच के आइए, आप सोच के आइए, देखिए ऐसे ना डिफेक्टिव सूट पर सुप्रीम कोर्ट तक लड़ने से ज्यादा अच्छा है आप इस पे कुछ कर सकते हैं तो सोच लीजिए। I will not say anything. You come tomorrow, we will hear you, and then you just figure it out whether you can file a fresh suit. Observation हम यहाँ पे कुछ भी नहीं देंगे।
My lord.
आपको जो करना है आपको खुद ही करना होगा। But if the suit is found to be technically not maintainable, then under such circumstances कैसे हम इसका
ठीक है।
मतलब
हम कल डिसीजन लेंगे। I will
हाँ, you
withdraw it
can-
and then with the liberty
नहीं,
to.
लिबर्टी हम नहीं देंगे, आपको बता दे रहे हैं, यू कैन प्रोसीड एज पर लॉ। हम कोई लिबर्टी यहाँ पे देने वाले नहीं, किसी भी एक भी शब्द में कोई सेकेंड अपील में हम लिबर्टी नहीं दे सकते हैं, मेरा जुरिस्डिक्शन नहीं है इस तरह का लिबर्टी देना, ठीक है? नॉट मेंटेनेबल। नेसेसरी पार्टी को आप पार्टी नहीं बनाए हैं, नॉन जॉइनर ऑफ नेसेसरी पार्टी है। ऐसे नहीं होगा।
My lord. Tomorrow.
You come tomorrow, right?
My lord. My lord.
ये 2:15 बजे।
All right.
Essay number 3(1) of 2017. After some argument, the direct counsel submits that the matter be posted tomorrow. अच्छे से देखेंगे, हम भी देख के आएंगे। What happened?
Serial number 34.
What have I done?
Leadership, I could not appear my leadership. Serial number 34.
I have not dismissed any case.
No. So
You have a date?
I'm ready to assist your lordship. Because
Order has already been passed.
leadership, I
You
was
come on
in.
the next date.
I think 36, second April 374 2017.
Just it was a little
No,
big
no,
court
no.
leadership. I cross a late.
कोई बात नहीं, हम आपको कुछ क्या किए हैं?
Cost
एक
लगा,
date
cost.
तो रहे।
नहीं leadership, please leadership. I'll ensure कि next time
नहीं।
I'll
नहीं, हम किसी का कॉस्ट रिकॉर्ड नहीं करते।
I'll ensure next time it is not.
कोई बात नहीं, 5,000 रुपए उसको देना है ना, क्लर्क एसोसिएशन।
नहीं
क्या
actually.
दिक्कत है? उनका कुछ आ रहा है।
नहीं leadership actually. एक बात this time. I go down to respect.
किसी का नहीं करते हैं, आपका नहीं करेंगे। आर्टिकल 14 का वायलेशन है। चलिए इस केस में कौन? आज हमको पता चला कि आप रिकॉर्ड लिए हैं इसलिए 5,000 किए, नहीं तो 20,000 से कम।
तो मेरा फाइल एक्चुअली लॉस्ट
हमको
हो गया
पता
था।
चला कि आप रिकॉर्ड लिए हैं इसीलिए सिर्फ 5,000।
I have read it everything but
Must have.
actually I was in court number 16 but
मस्ट हैव, नो प्रॉब्लम। तो 4 जूनियर रखिए, अच्छे वाले।
नहीं मेरी जूनियर है उसको फीवर हो गया शी वाज रनिंग विद फीवर आई सेड डोंट कम दैट वाज द डिफिकल्टी
कोई बात नहीं, नेक्स्ट डे इंटरव्यू।
Item 36. Item 36.
आपका केस
item 36 minute, I believe it may be taken up in the next week.
सर कॉस्ट दे के एडजर्नमेंट हुआ है सर.
In fact, yesterday my internet was not working. I could not get ready. यहाँ कोर्ट में मेरे हम लोग के चेम्बर में भी नहीं, बहुत स्लो है. यहाँ आकर के हम लोग काम कर रहे हैं.
नहीं सर, आपको 1000, 2000, 4000
हाँ,
ऐसे ऐसे कॉस्ट लग चुका है आपको. 8000 भी लग चुका है.
हाँ, वो क्लाइंट फाइल का और भी जो पार्ट्स होता है वो लाके देने में किया.
टाइम नहीं.
आज पाठक कर लीजिए, हम प्लेस कर.
पार्टनर क्या करना है ऑर्डर 41 रूल 11 में.
तो my lord,
पार्टनर का कोई स्कोप कोई फाइनल नहीं.
very frankly, I am saying that today I have not been
I will
able-
adjourn it with the cost. I will adjourn it. आपको
हम तो
जितना
यहाँ पर
time
है आपके सामने.
तो वैसा.
And I'm placing the difficulty. It is very practical. Even
Sir,
the
ऐसे
net is
नहीं.
not working in this honorable court, in the lawyer's side. It is
ये समीर जी, ये केस लास्ट का लिस्ट हुआ था. लास्ट का लिस्ट हुआ था.
अभी हाल फिलहाल तो शायद नहीं हुआ.
बताइए. 28/8 को लिस्ट हुआ था. 27 को प्रोग्रेस में नेक्स्ट डेट दिया होगा. हमारे यहाँ कोई भी केस बिना डेट का नहीं होता.
उसके बाद
And it has come on a date fixed.
हाँ, तो आपके यहाँ हर केस में डेट
तो
फिक्स होता है.
फिर आप कैसे बोलते हैं कि आपको पता नहीं था?
इसको tomorrow
नहीं, टुमारो हम नहीं करेंगे. आप फाइल खोलिए.
माने
फाइल खोलिए. फाइल खोलिए ऐसे.
अभी
इसीलिए आप ये नहीं बोल सकते कोई चीज आपको अचानक पता चला. यहाँ इस कोर्ट में कोई चीज किसी को अचानक नहीं पता चलती.
मैं अचानक my lord,
इसीलिए हम वेरीफाई किए, क्योंकि अगर मेरे पास केस लिस्ट हुआ है then every case has a date. You can get the date on the next day. उसके लिए आपको अगला डेट तक वेट नहीं करना.
तो मालूम.
तो फिर आप ऐसे कैसे बोलते हैं कि आपको लिस्ट
मालूम.
नहीं आया इसलिए अपलोड नहीं
नहीं, वो तो
हुआ,
हम नहीं बोल रहे.
सर्वर डाउन है
This is-
और
नहीं.
आपको पता नहीं चला.
The reason is my lord will see the judgment, two judgments to this case, the trial court and the appellate court, and see the font.
क्या फॉर्म किया?
कितना छोटा फॉन्ट आप देखिए.
आप A4 में फोटोकॉपी कराए होंगे.
हाँ,
हाँ, तो इसीलिए ना लीगल साइज का चीज को आप A4 में करा दीजिए तो आपको फॉन्ट दिखेगा ही नहीं. इसमें गलती किसका है?
अच्छा, इतना छोटा फॉन्ट क्यों
फॉन्ट इसलिए है छोटा सर क्योंकि आपने लीगल साइज के पेपर को A4 साइज में फोटोकॉपी कराया. ये टेक्निकल चीज तो आपके जूनियर को पता होगा. आपको भी समझ आ रही है क्या बोल. समझ आया ना आपको? दैट इज द रीजन. ऐसा नहीं है कि प्रिंटिंग छोटी है. हाँ, लीगल
एक काम करते हैं, हम समझ गए. आई गो डाउन. देखिए, जब रीजंस है तो उसको फॉलो करना चाहिए. तो ऐसा करते हैं, ट्रायल कोर्ट जजमेंट इज द जजमेंट ऑफ रिवर्सल. इनफैक्ट
पढ़िएगा साथ. इतना क्या है, पढ़िए. मान लीजिए कुछ प्रॉब्लम होगा तो टाइम दे देंगे. ऐसा थोड़ी.
नहीं, प्रॉब्लम नहीं है.
फाइल खोलने में 15 मिनट की.
यही पर खुला हुआ है.
आप तो बस खोलिए, पढ़िए. क्या बात है? टाइटल सूट करेक्ट. What were the issues?
Here, the case is very small, in a very short, which I can say that one Hemant Koiri married, first wife name was Lalia, and the name of second wife was Lilia. Now, the trial court found that Lilia was not entitled to any share. She was not the wife. She was there for her own bharan poshan, for her own existence, and therefore the trial court dismissed the suit. The plaintiffs purchased from the second lady, and the court said that she had no right to sell the property. She was
Because
not
she
the
was not the wife.
हाँ, this is the trial court says. I have read it. ऐसा नहीं कि एकदम से blind है. पहले पढ़े होंगे. तो there the court dismissed the suit. In appeal, the court has reversed the judgment and has decreed the appeal by saying that she was wife. कोई डेट ऑफ मैरिज नहीं है, कोई एविडेंस नहीं है कि कब शादी हुई, कौन कौन अटेंड किया, एंड all people are of 60, 65, 70 years of age, the witnesses. Marriage was held within that time.
Court has the court recorded a finding that this
Second lady was the wife.
this Heman Mehto
हाँ.
had two wives.
The trial court refused to accept it.
What happened? The appellate court.
Appellate court said कि second wife थी, तो husband के death के बाद उसको agree कर गया, और
Second wife कब circumstances में हो सकता है?
अगर after the Hindu Succession Act हुआ है तो wife ही नहीं होगी.
नहीं.
Before the Hindu
एक
Succession,
second. First wife के मरने के बाद भी second wife हो सकती है.
हाँ हो सकती है.
What is the date of death of the first wife?
कुछ नहीं दिया हुआ है.
Who pleaded what?
The plaintiff has to plead that Hemal Mahto's first wife died on such and such date. Thereafter, he married the second lady.
Has the plaintiff said that there were two marriages of Hemal Mehto?
हाँ,
He has said
हाँ,
so.
but
That
date नहीं
he
देता.
married twice.
हाँ, डेट नहीं देता.
आप पढ़िए तो सर से नहीं पढ़ाएगा. आप पढ़िए. प्लेंटिफ का केस बताए. आप तो हैं.
My lord, I will pray that trial court judgment may kindly be seen because that has been reversed. The reasons will be clear that how he has dismissed the suit, and then my lord will find that how the court, appellate court has reversed the judgment.
Para 3 of the appellate court judgment.
इसी का जजमेंट से तय
सर पूरा इंग्लिश में उसका केस हिस्ट्री है. उसको
अच्छा.
पैरा 3 पढ़िए.
Para 3. The case of the plaintiff appellant as per plaint is that the land of the Raiti Khata number 14 of Moja so and so, Thana number so and so, district Hazaribagh, now Giridih, was recorded in the name of Chundo Koiri during the last cadastral survey and settlement operation, and he was in possession over the same. Chundu Koiri died leaving behind his 4 sons, namely Mani Koiri, Tiki Koiri, Seva Koiri, and Kulash Koiri, who inherited their father and came in possession over the said land of Khata number 14. The said 4 sons of Chundu Koiri affected amicable partition of all their land of the joint family, including the lands of Khata number 14, in 4 equal shares, and each of them came in separate possession over their respective share of land. Further, the plot number 580 is one of the plot in the said Khata, which has total area of 1.40 acre. In the said partition, Mani Koiri got 0.35 acre of land, as also other lands. Mani Koiri died leaving behind 3 sons, namely Heman Koiri, Nemchand Koiri, and Jeevan Koiri, who inherited their father and came in possession over the land of their father. Heman Koiri, Nemchand Koiri, and Jeevan Koiri also affected amicable partition of all the lands left by their father, including the said land, 0.35 acre of land in plot number 580 about 55 years ago, and came in separate possession over their respective share of land. In said partition, each of the brothers got 0.11 2/3 acre of land out of plot number 580, as also other lands. Further, in the said partition, Heman Koiri got 11 2/3 acre of land, which is described in Schedule A below. Further, Heman Koiri died about 50 years ago, leaving behind his widow Musmat Lilia and her daughter Sovia Devi. Musmat Lilia stepped into the shoes of her husband and came in possession over the land of her husband, including the lands described in Schedule A below. Further, after the death of first wife, Heman Koiri married with Lilia Devi, and after death of Heman Koiri, his wife Musmat Lilia inherited him.
There is a story that the first wife died first, and thereafter he married again. So ऐसा नहीं है. This story is not there. It's not like that.
That is
There is a clear story on this. आगे पढ़िए.
Dular Mahato and Mosmat Lilia jointly sold lands to Sukri Devi and Khiro Mahato by virtue of registered sale deed dated 25/6/1961. It is further pleaded that Mosmat Lilia sold lands area 3.64 acre out of her share in the lands of Khata number 99, 46 and 14, including Schedule A land to Khiro Mahato, Todi Mahato, Badri Mahato, Jhari Mahato and Jagdish Mahato by virtue of registered deed of sale dated 16/11/1981 and put them in possession over the same. Further said Musmat Lilia sold her remaining lands in Khata number 99 to Todi Mahato, son of Tahlu Mahato by virtue of registered deed of sale dated 21/1/1982 and put him in possession over the it is not legible now. Thus, by virtue of the said sale deed dated 16/11/1981 and 21/1/1982, entire share of Musmat Lilia, which she had inherited from her husband, was sold and nothing remained with her in the lands of Khata number 14, 46 of Moja Suyadi and Khata number 99 of Moja Pesa. Further, on 25/2/1982, Dular Mahato, son of Nemchand Quail, is alleged to have got a sale deed executed by Sobhya Devi, the daughter of Hemal Quail and wife of Numman Mahato, which is illegal, inoperative, void. The said Sobhya had no right, title, interest, or possession on the land purported to be sold by the sale deed, nor the purchaser Dular Mahato acquired any right, title, interest, or possession over the said land. The said sale deed always remained a paper transaction which never saw the light of the day. Further, Khiro Mahato, Todi Mahato, Badri Mahato, Jhari Mahato and Jagdish Mahato applied for mutation of their names with respect to their purchased land by the sale deed dated 16/11/1981, which was registered as case number 136 of 1982-83 of Anchal Adhikari. Dular Mahato filed objection in the said mutation case in which Karamchari, CI and Anchal Adhikari made spot verification and found possession of Todi Mahato, Badri Mahato, Jhari Mahato, Jagdish Mahato and Khiro Mahato in possession over their respective purchased land and rejected the objection of Dular Mahato and mutated the name from the said persons who are plaintiffs in this case. Further, Dular Mahato by underwent means got a letter issued from the court of LRDC Giridi bearing letter number so and so dated 27/2/1986 to Anchal Adhikari, Birni, for cancellation of demand running while mutation case number 136 of 1982-83 and 137 of 1982-83 on the basis of the said sale deed dated 25/2/1982 in favor of Dular Mahato in register 2 of Village Suyadi and Pesa. Plaintiff moved the court of additional collector Giridi against the said illegal order of LRDC Giridi, and the same was set aside by the additional collector Giridi by order dated 15/7/1987 passed in miscellaneous case number 153 of 1986-87. In the meantime, on the basis of the letter dated 27/2/1986, the Anchal Adhikari had opened demand in the name of Dular Mahato, which demands were cancelled by Anchal Adhikari Birni, passed in miscellaneous case number 2 of 1987-88, and also ordered to continue the demands of the plaintiffs as usual. Against the said order passed by the Anchal Adhikari Birni, Dular Mahato moved the court of LRDC Giridi, which was dropped by order dated 22/7/1988, in view of the order of the additional collector Giridi dated 15/7/87, passed in miscellaneous case number 150.
You see these sale deeds, who were claiming the property by virtue of these sale deeds?
The subsequent purchasers by the Lydia Devi were claiming the property.
Plaintiff was not aggrieved by any of the sale deeds. Because no sale deed is under challenge. There is no challenge to any of the sale deeds.
They are moving the revenue authorities time and again for
Maybe.
mutation issue.
That's right. But sale deeds are not under challenge.
Our claim is that the vendor itself did not possess the right, title, interest to pass on the title by
Whom?
to the plaintiffs.
Plaintiffs were, just a moment, you say that he did not have the right title and interest to pass on the claim. At the same time, you say that no consideration amount was paid. Right? But these are matters of adjudication. You are not challenging the sale deeds, by virtue of which the plaintiff is claiming title over the property. You are not challenging the sale deeds. The suit is barred under Section 34. The suit is barred under Section 34, isn't it?
Cancellation of sale deed suit has not been paid, and we are not the plaintiffs.
You are the defendants. The plaintiffs are claiming that property by virtue of registered deeds, which are not under challenge. Then
Defendant's cases starts from para 5.
yes, I've seen. But then, assume. You tell us. After some argument, the Learned Counsel for the appealant raised for adjournment post tomorrow. देख लीजिए सर, हमको नहीं लग रहा कोई केस को दाम. Next.
Tomorrow I will be permitted.
Sir?
Tomorrow I will be permitted to continue the argument.
Oh yes, certainly. आज तो उनको इसलिए बोले कि वो भी तो कुछ
आज
करेंगे
एक
ना.
बार तैयार नहीं करते. कल घर में वो माता पिता जी का तो वार्षिक श्राद्ध वाला प्रतिपक्ष में पूजा हो, उसमें टाइम लगेगा, इसीलिए हम
2:15 बजे है ना सर?
जी
2:15 बजे.
हाँ हम आ जाएंगे.
ये तो 2:15 ही बजे.
हम आ जाएंगे.
Item 37, second to 376 of 2017.
Your Ladyship, in this case, I received information last week that applicant number 1 and defendant number 6 has passed away during pending. Date of applicant number 1 I have received, defendant number 6 I am not aware yet. Applicant number 1 died on 29/6/2025. Death certificate is updated.
Essay number 376 of 2017. The Learned Counsel for the appellant has submitted that the appellant number 1 has expired on 29/6/2025, and the defendant number 6 has also expired, but he is not aware about the date of death. Timely step ले लीजिए.
एक्चुअली डेथ सर्टिफिकेट आया नहीं है हमारे पास, उनके पास भी नहीं आया, इसीलिए थोड़ा
कोई बात नहीं, आप डेट ऑफ डेथ तो शमशान घाट का कहीं ना कहीं का तो मिल ही जाता है ना. ऐसा नहीं है कि
अप्लाई किए हुए
टोटली अनरिकॉर्डेड हो.
नहीं. हाँ,
डॉक्टर का सर्टिफिकेट हो सकता है, मुखिया का डॉक्यूमेंट हो सकता है, देयर आर सो मेनी थिंग्स. शमशान घाट का सर्टिफिकेट हो सकता है, कुछ तो प्रूफ लगाएंगे. The suit has been held to be not maintainable.
suit concurrent finding is there.
Suit is not maintainable on account of non-joinder of necessary party.
It was a finding that DC
Is a necessary party.
is a necessary party.
Certainly is a necessary party as per the statute. Isn't it?
And it should have been made party, but there are several questions of law because there are
बाकी
earlier
क्वेश्चन ऑफ लॉ से क्या ही मतलब है?
Because earlier there was a litigation between the parties.
If the
And
suit
the
is
main
not maintainable, the matter ends. If the suit is barred by limitation, matter ends. क्योंकि second appeal में तो नहीं चलेगा ना ये सब. Second appeal में we are not supposed to answer every question of it. There has to be a substantial question which has a bearing in the matter.
In the main case, it has been dismissed, the title suit.
We'll see that when you want.
At least 2 weeks time may be given for filing that substitution petition.
2 weeks आप अगर time लेंगे
Litigation.
तो आपका applicant का substitution petition में आपका abatement limitation सब
नहीं आ
लगेगा.
जाएगा क्योंकि 29th is the date I have just checked and 90 days is there in addition.
हाँ तो 29th September
Within 2 weeks I will file. That is why I am saying.
ठीक है.
Within 2 weeks.
25th रख दे.
Yes. I will
25th
file.
25th September.
Orders to be deferred item 21, second appeal 239 of 2018.
We have filed an appeal for ignorance of the defect.
Which defect?
Defect number 1, there is only one defect pursuant to failure of consolidated memo of order, which was to the effect that one additional execution of Mr. Abhijit Kumar Jha at Wakalatnama may be verified. Abhijit Kumar Jha, alias Monu Jha, and Abhijit Kumar Jha, they all are same person. They have given a statement to that.
Statement से नहीं होता है.
And
Statement second appeal में alias का statement नहीं चलता.
we have also enclosed his Aadhaar copy and the name by which he executes.
ये defect ऐसे नहीं ignore. Not possible. 19/12/24. What is the order dated 19/12/24?
1920 to file a consolidated memo of appeal. Whereafter fresh stamp reporting was required to be carried out.
ये consolidated appeal आपने फाइल कर दी. ये defect number 1 क्या है? पढ़िए. What is the defect number?
One additional execution of Mr. Abhijit Kumar Jha at Wakalatnama may be verified.
What does that mean? Additional execution means what?
This वकालतनामा में सिग्नेचर है अभिजीत कुमार झा एलियस करके मोनू झा कर दिया गया है. वो वैसा ही आया ही होगा. तो since his Pukaru name was Monu Jha, so or he has been impleted before the appellate court by the name of Monu Jha only.
तब मोनू झा ही रखिए ना, बाकी क्यों?
Official documents में उसका signature जो है उनका my lord वो
नहीं हो
अभिजीत
सकता
कुमार
ना
झा.
ऐसे नहीं हो सकता है. आपको किसी को भी जब मन होगा किसी का एलियस नाम है ऐड कर देंगे. नहीं हो सकता.
Alien नाम
आप अपीयर किए थे ना ट्रायल कोर्ट में?
ट्रायल कोर्ट में अपीयर हुआ था.
Appellate court में किया है.
सब्स्टिट्यूट होकर आया हुआ था.
हाँ तो वहाँ पे किसका वकालतनामा बताइए.
वहाँ पे my lord वहाँ पे
You must have appeared by filing वकालतनामा.
my lord.
So
But in-
second appeal में for the first time we are not going to hear any alias name. No, we will not permit that. मोनू झा के नाम से डिग्री होगा, उसके बाद जो एलियस नेम वाला आके जो है प्रॉपर्टी ले लेगा. We will not permit that.
एफिडेविट पे मैं नॉट
Affidavit का क्या value है?
फादर से पेरेंटेज एक सबका हमने बताया रेसिडेंट ऑफ वही एड्रेस है सिंस एट दैट टाइम उसका पुकारू नाम मोनू झा था तो वो बाय नेम ऑफ मोनू झा ही बन गया पार्टी इसीलिए ऐसा ये डाला
You were substituted.
माय लॉर्ड सब्स्टिट्यूशन
Your father's name is
अजीत झा
Ajit Jha was a party in the suit. Ajit Jha was a party in the suit. But then
लेट कोर्ट जजमेंट माय लॉर्ड
was Ajit Jha a party in the suit? उनका वकालतनामा कहाँ है भाई? अब कब फाइल किया वकालतनामा?
वकालतनामा 11/6/2018 का
Along with the main memo of appeal.
along with main memo
Were you substituted or you were not substituted?
और एपलेट कोर्ट का जजमेंट में कंसोलिडेटेड मेमो ऑफ अपील लेकर जाएगा 1C 1D एंड 1E करके डॉटर ऑफ सन ऑफ अजीत झा का सब पार्टी बनाया गया
तो ट्रायल कोर्ट का जजमेंट में या ट्रायल कोर्ट का प्लेंट में राइट अजीत झा के पिताजी का नाम भी होगा करेक्ट if you say that you are the son of same Ajit Jha and you want to have the benefit of his alias name तो अजीत झा का भी आइडेंटिटी फाइल करिए ना अजीत झा के what was the name of father of अजीत झा इतना आसान नहीं है एलियस नेम को यहाँ इंक्लूड कराना if you have an alias name with Mr. X right Mr. X will claim the property or you will claim the property होगा ना
if one and if both are one and
who will decide whether they are one and the same person the only document which can further come on record is the identity card of your father उनका आधार लेके आइए उनका डॉक्यूमेंट लेके आइए
ट्रायल कोर्ट में
ऐसे नहीं होगा we will not permit this नहीं हो सकता you have to prove the identity of your father उनका कोई डॉक्यूमेंट होगा ना आपके पास
देखना होगा इसमें प्लेंट वगैरह
you will not permit this it is not practically possible देखिए ऐसे नंबर 239 of 2018 IE number 11692 of 2025 has been filed, seeking to ignore defect number 1. As per defect number 1, the appellant number four, namely Monu Jha, son of late Ajit Jha, has put his signature in the wakalatnama as Abhijit Kumar Jha alias Monu Jha. The learned counsel submits that Abhijit Kumar Jha and Monu Jha are one and the same person. Which document have you filed that they are not the same person?
Aadhaar card is there annexure में.
इसमें तो मोनू झा तो कहीं नहीं है.
मोनू झा पुकारो नाम था अभी.
The learned council has submitted that the appellant has that Monu Jha has filed his Aadhaar card along with the interlocutory application. He has also submitted that at the stage of trial, his father Ajit Jha had expired and he along with others were substituted. इसमें 3 नाम है आपका एफिडेविट में.
My lord, because signature वो ABHIJEET करते हैं और आधार पे ABHIJIT लिखा गया है, तो उसको
इतना इंग्लिश नाम कैसे चलेगा?
सिग्नेचर उनका.
From the affidavit, it appears that the interlocutory application has been filed by Monu Jha alias Abhijit ABHIJEET, Kumar Jha alias ABHIJIT Kumar Jha. The learned counsel for the appellant is directed to seek instructions and file an appropriate affidavit. Of appellant number 5, उनका फाइल कर दीजिए, फुल ब्रदर का.
appellant number
5 Vicky Jha, who appears to be full brother of Monu Jha as per the memo copy.
that he may declare that they are one and same person.
ठीक है, जगह इससे.
I have also as an precautionary I have obtained the other wakalatnama also, but since
आप उनका एफिडेविट फाइल कर दीजिए ना.
Vicky Jha का.
ठीक है.
My lord,
Then we will ignore that.
there are 2 more IAs also, my lord, for
अभी आपका यही डिफेक्टिव है. अभी क्या है आपका?
substitution.
कब रख दें बताइए?
2 weeks.
Post on 25th,
25th
25 सितंबर. उसके बाद रखना, छुट्टी बाद.
छुट्टी के बाद.
कौन सा छुट्टी के बाद?
ये
होली दिवाली.
नहीं ये 6th.
6th of August.
Item 22, second appeal 185 of 2019.
That's deficit totally I
You pay. Defective है.
There are 2 IAs, one for ignoring the defect. Defect is that the name of Musammat Lakshmi Devi, she has not been included in this memo of appeal. She was a party in the degree under appeal.
An officer has not pointed out.
She has died. It is a defect.
She has died.
She has died just after the passing of the judgment.
Just after the passing of the
Judgment and decree under appeal.
तो उनका legal here.
Legal there, sir.
पैरा 5 में लिखे
आपका डेथ सर्टिफिकेट लगाएं।
सन एंड डॉटर्स
पहले तो आप कोर्ट फीस पेमेंट करिए, उससे पहले कोई और कर दिए।
हाँ।
Ignoring the defect.
लाइक
आइए
आइए नंबर 1117 अब पैरा 5 में she died on 17/10/2018 after passing away judgment and decree under the leaving behind one son named Om Prakash Singh, appellant number 1 and 6 daughters who are appellant number 4 to 9.
उनका डेथ सर्टिफिकेट कहाँ है?
That's
आप अपीलेंट ही है ना,
हम
तो डेथ सर्टिफिकेट कहाँ है? कैसे मानेंगे आपका कि जजमेंट एंड डिक्री होने के 5 दिन बाद उनका डेथ हो गया?
या पैरा 5 में लिखे
आपके लिखने से नहीं, कुछ प्रूफ चाहिए।
17/10/2018 11/10/2018 कर दिए।
कुछ डॉक्यूमेंट लेके आइए। ऐसे नहीं, दोनों में बहुत फर्क है। जजमेंट के पहले मरना, जजमेंट के बाद में मरना, आर्गुमेंट के बाद में मरना, ड्यूरिंग द पेंडेंसी मरना, all of them have different implications. एक कोई डॉक्यूमेंट लेके आइए, मुखिया से लिखवा के जाए कहीं से।
और एक का ड्यूरेशन ऑफ डिले 159 days
159 days
like
कहाँ है? आइए बताइए। आइए नंबर
आइए नंबर 11721 फ्लैग बी
11721। हम लोग के ऑफिस को गिनती नहीं आती है। 11721 ऊपर नीचे जहाँ तहाँ लगा देखिए। आई नंबर 11721 of 2025। The learned counsel for this petition has been filed seeking condonation of delay in filing the present appeal. Another petition behind number 11720 of 25 has been filed seeking to ignore the defect as pointed out by the office by stating that Mausamat, which has been as pointed out that Mausamat Lakshmi Devi has not been made party in the second appeal. The learned counsel submits that she died on 17/10/2018 after the passing of the interim judgment and decree, leaving behind only one son named Om Prakash Singh, who is the appellant number 1 in the present case, and 6 daughters who are appellant number 4 to 9. And accordingly, the legal heirs and successors of Lakshmi Devi is already on record. Issue notice to the respondents on both their procedural application, for which requisites under speed post be filed within a period of 4 weeks from today। 4 हफ्ता दे दिए, दोनों में स्पीड पोस्ट एंड ऑर्डनरी कर दीजिए। वैसे भी सेकेंड अपील कैसे सुनवाई करेंगे विदाउट हियरिंग देम? पोस्ट ऑन बोथ दाएंगे, पोस्ट ऑन 24 नवंबर। इस बीच आपको कोई डॉक्यूमेंट मिले तो लगा देंगे, अगर वो लोग डिस्प्यूट नहीं करते हैं तो आप अलाउ कर देंगे। चलिए, आई गाइस नाउ Are you waiting for something, Mr. Mehta? बारिश हो रही है।
Today it has rained like anything.
Oh, I have no idea.